Get ready? Start. 39. When an oral order of the learned judge passed in the original suit of the Bombay High Court was challenged by the petitioner therein by way of a writ petition under Article 226 of the Constitution of India before the Bombay High Court, comma, the writ petition was dismissed by a division bench of the Bombay High Court on the ground that the impugned order was a judicial order of the High Court and was not amenable to writ jurisdiction under Article 226 of the Constitution of India. Stop. Thereafter, comma, the petitioner therein moved this court under Article 32 of the Constitution of India for enforcement of his fundamental rights under Article 19 of the Constitution of India. Stop. This court observed that the impugned order was passed by the learned judge in the course of trial of a suit before him after hearing the parties. Stop. This court took the view that the restraint order was passed to prohibit publication of evidence in the media during the progress of the trial and could not be construed as imposing a permanent ban on the publication of the said evidence. Stop para 40. The question which fell for consideration before this court was whether a judicial order passed by the High Court prohibiting the publication in newspapers of evidence given by a witness pending the hearing of the suit, comma, was amenable to be corrected by a writ of certiorari of this court under Article 32 of the Constitution of India. Stop. In the above context, comma, this court first held that a judicial verdict pronounced by a court in a matter brought before it for its decision cannot be said to affect the fundamental rights of citizens under Article 19 in bracket 1 of the Constitution of India. Stop. Thereafter, comma, this court proceeded to hold that if any judicial order was sought to be attacked on the ground that it was inconsistent with Article 14 or any other fundamental rights, comma, the proper remedy to challenge such an order would be by way of an appeal or revision as may be provided by law. Stop. It would not be open to the aggrieved person to invoke the jurisdiction of this court under Article 32 of the Constitution and to contend that a writ of certiorari should be issued to quash such an order. Stop. This court observed that it would be inappropriate to allow the petitioners to raise the question about the jurisdiction of the High Court to pass the impugned order in a proceeding under Article 32 of the Constitution of India. Stop.